Next, we have some new video in the Sheriff Sean Mickey Steins case. That's right. Sean Mickey Steins fatally shot a district court judge by the name of Kevin Mullins inside the county courthouse in an act that obviously was quite shocking to the small Kentucky community. The two men, who had been friends for over 30 years, had shared lunch just hours before the incident, and surveillance footage captured the moments leading up to the shooting and showing Steins drawing his gun as Mullins' attempt to hide behind the desk. But minutes after the shooting, the Kentucky State Police arrested Steins in the courthouse hallway, and new body cam footage revealed a paranoid Steins visibly shaken and handcuffed, expressing fear that he would be killed during transport to the county jail an hour away. He said, quote, "I leave this building, I won't draw another breath," he told the troopers, begging to be held in the nearby Letcher County Jail instead. Now, despite these reassurances from the Kentucky State Police investigators, Clayton Stamper, Steins remained convinced that someone would intercept the transport and murder him. Steins' attorneys are preparing an insanity defense, arguing that 2 weeks of intense stress compounded by a recent deposition drove him to commit the murder. Now, the deposition was part of a lawsuit filed by Sabrina Atkins, addressed allegations that a deputy sheriff sexually assaulted inmates in Mullins' chambers. Atkins also accused Mullins of engaging in sex for favor schemes, and Steins reportedly feared retaliation following his testimony, believing his wife and daughter were at risk of kidnapping or harm. Now, moments before the shooting, Steins used Mullins' phone to call his daughter and later told officers, "They're trying to kidnap my wife and kid." Anyway, the defense attorney for Steins emphasized that Steins' mental state will be central to the trial, stating that he was in fear for the safety of his wife and daughter. And I think that you'll see there is a result of that, the attorney has stated. Now, Steins obviously has pled not guilty to the murder charge. The motive behind the killing remains unclear, and the only vague explanation provided so far is what you've got. Now, the lawsuit allegations and Steins' deposition testimony are expected to play a significant role in unraveling the events that led up to that particular moment. That's right, Bryan Kohberger. What did he tell his dad when he called him in the early morning hours of November 13th, 2022, after he allegedly committed a quadruple homicide? That's right. New revelations have emerged in the case of Bryan Kohberger, obviously the criminology PhD student accused of murdering 4 University of Idaho students back on November 13th of 2022. Well, court records indicate that Kohberger made 3 phone calls to his father, Michael Kohberger, starting at 6:17 a.m., just 2 hours after the alleged murders, which occurred shortly after 4 a.m. Now, the calls, lasting up to 54 minutes, were placed from Kohberger's phone near his apartment in Pullman, Washington, though the content of these conversations obviously remains unknown up to this point. Now, it's unclear whether such early morning calls were typical, as Kohberger's parents obviously resided in Pennsylvania, Albright, Pennsylvania to be exact, where the first call would have been received about local time, about 9 a.m. Now, prosecutors allege that Kohberger disabled his phone and then put it on airplane mode during the time of the murders to avoid detection. Surveillance footage captures a white Hyundai Elantra, believed to be Kohberger's, circling the victim's home at 1122 King Road. They're in Moscow, Idaho, not Moscow, Idaho, as I've been informed, before the attack. Then at 9:12 a.m., Kohberger's phone pings on a cell tower near the crime scene, suggesting that he returned to the alleged crime scene. And by 10:31 a.m., he was back at his apartment, where he took some disturbing selfies, smiling with his thumbs-up gesture in front of the shower. The victims' bodies were discovered just before noon when a 911 call was made. Now, as you may recall, Kohberger was arrested on December 30th of 2022 at his parents' home in Pennsylvania, where he had traveled for the holidays. His father had joined him in Pullman, Washington earlier that month for the cross-country drive, during which their white Hyundai Elantra was stopped twice by police. Prosecutors do plan to call Kohberger's family members possibly Father Michael, Mother Marianne, and sisters Amanda and Melissa as witnesses in the capital murder trial set to begin on August 11th there in Ada County. Now, the specifics of their testimony remain confidential, though Kohberger's defense team and say that his family supports him and they're unwilling to aid in their son's prosecution. In a notable ruling, though, the Judge Hippler, permitted Kohberger's immediate family members to attend the trial daily, even before they are called to testify. Now, further details reveal Kohberger's activities. You can take them for what it's worth. On August 16th of 2022, he allegedly searched for Ted Bundy and a professor's paper on the serial killer. Post-murder, he watched shows about Bundy, including a YouTube video, Ted Bundy, Essence of a Psychopath, on December 28th, 2022, and took selfies mimicking Bundy's hooded appearance. Kohberger also listened to Britney Spears' songs Criminal and searched for news about the murders and his own name. His phone contained numerous images of female students from Washington State University and the University of Idaho. And these were all sourced from social media accounts linked to victims, Kaylee Gonsalve and Madison Mogen and Zana Kernodle. Investigators believe Mogen was the primary target, as the killer allegedly went directly to her third-floor room, where Gonsalves was also present. A struggle alerted Kernodle, who was downstairs, leading to her and Ethan Chapin's death. The killer reportedly sat in a chair in Kernodle's room before exiting via a sliding door, passing survivor Dylan Mortensen's room. And Mortensen's described seeing a masked figure with bushy eyebrows. She and Bethany Funk, another survivor, hid and later discovered the bodies. A sixth roommate who had moved out of the home but was coming back, obviously had some last-minute changes to her schedule and potentially escaped a horrible fate. Now, evidence tying Kohberger to the crime scene includes the DNA on the K-bar knife sheath found next to Mogen's body, matching his profile, and his Amazon purchases for a similar knife and sheath back in March of 2022. His Hyundai Elantra matches the vehicle seen fleeing the scene, and cell phone data suggests he stalked the house at least 12 times before the murders. Now, the murder weapon remains missing, though Kohberger allegedly searched for a replacement knife post-crime. As the trial approaches, these details continue to obviously shed a little more light on the tragic events of November 13th of 2022. And remember, Bryan Kohberger is given the presumption of innocence because he has not pled guilty, nor has he been convicted of a jury of his peers. Bryan Kohberger has named an alternate suspect who he claims is the real killer of the 4 University of Idaho students. Now, in this big bombshell move, just weeks before he starts trial, that's right, we'll see what it actually is. Now, it's sealed, of course, and we're going to have a hearing. But the suspect of accused of the quadruple homicide turned to a courtroom today where Judge Hippler is expected to make a series of last-minute decisions that will shape the capital murder trial starting in August. Now, in an 11th hour move to save Kohberger from the firing squad, the defense took the explosive step to pointing the finger at another suspect. Now, who this suspect is and what evidence the defense has that could be necessarily tying this person into the brutal murders, well, it remains a mystery. Now, the judge ordered that the defense filings remain under seal, keeping it cloaked in secrecy until trial. Now, the defense team for Kohberger has previously revealed plans to argue he was framed and that 2 killers must have committed the shocking crime. Now, like I said, Judge Hippler gave Kohberger's a deadline of May 23rd to hand him whatever actual evidence you have that supports those allegations other than just making an allegation. He also ordered the defense to provide to the judge how it is you believe that you are going to offer this evidence and why is it even admissible at trial. The state will then have until June 6th to respond to the defense claims before the two sides battle it out in a hearing later that month. The judge will then rule on whether the jury can hear about this alternate suspect or not. Now, this move by the Kohberger defense team comes less than a week after new details emerged in this case, including the phone calls to family members after the murders The chilling porn choices and the disturbing online searches about the serial killer Ted Bundy. Kohberger is facing the death penalty if convicted of the brutal murders of Kaylee Goncalves, Madison Mogen, Xana Kernodle, and Ethan Chapin. Now, as part of the hearing, the judge could determine what final pieces of evidence the jurors will be able to see and hear to decide the fate of Bryan Kohberger. And among those final pieces of evidence still in play is the research paper intricately detailing a fictional crime scene about a woman being stabbed to death at a trailer park. Phone records and bank transactions for both the accused killer and some of the alleged victims, as well as surveillance footage from locations close to the crime scene, are also likely to be discussed. Now, the trial is expected to last about 3 months. And that does not include the sentencing phase if necessary. Who knows? Bryan Kohberger could be found not guilty at trial. Obviously, he's entitled to the presumption of innocence. The government hasn't presented any evidence at this point because the trial hasn't started, obviously, but he is given that presumption. Now, obviously, if presumption of innocence is overcome and Bryan Kohberger is convicted, he faces the death penalty, and following recent changes in the Idaho state law, could face a firing squad, which, if he were convicted and if that were to take place, unless he waived all his appeals, could probably take another 2 to 3 decades before any execution ever took place, if at all. To date, 13 separate defense efforts to take the death penalty off the table have been denied by the judge, including one where they cited to this autism spectrum disorder diagnosis as a reason to block Kohberger from the capital punishment. The judge has also dealt a series of other blows to Kohberger's defense strategy in recent weeks, ruling that jurors can hear the 911 call made by the victim's surviving roommates and see their panicked texts after Mortensen saw the masked killer inside the home. Now, the judge has also ruled against Kohberger in allowing Mortensen to describe the man inside her home using the term bushy eyebrows. Jurors will also be able to see Kohberger's Amazon shopping history, which prosecutors say reveals that he bought, curiously enough, a K-bar knife and sheath and a sharpener from Amazon back in March of 2022. A matching sheath was found next to Mogen's body, with DNA on the sheath being traced back to Kohberger. Now, of course, the murder weapon has never been found. And like I said, Kohberger is entitled to that presumption of innocence. It's going to be interesting. Now, alternate suspect evidence. Just to say we believe somebody else did it is not enough. Now, remember, the prosecution always has to prove identity, that it was in fact Bryan Kohberger, that it was him, not someone who looked like him, not someone using his identity, but it was in fact Bryan Kohberger that committed the crime. Now, unless there is a confession of a third party, unless you can prove that that person was at that house that night and basically had a K-bar as well, I guess, or some other instrumentality of death that could be used, would be consistent with the murders, the chances of the defense being able to actually present this evidence at trial is pretty unlikely. And even if the judge says, okay, I think there's some relevance here, I'll give you a little bit of leeway, then the defense has to be able to get that evidence into evidence and it not be hearsay evidence. There has to be some exception to the hearsay rule. And just to say somebody was in the vicinity or somebody was out walking their dog that particular evening, there's no indication that ties him to any other. Like I said, I've been doing this a long time, ladies and gentlemen. Tried alternate suspect numerous times. Normally, they are shot down. Very, very unlikely unless you've got some pretty clear smoking gun. It was kind of like, well, we could have charged this guy or we should have charged Bryan Kohberger and we'll just pick Bryan Kohberger, right? I'd be very surprised. Now, I haven't seen the evidence. We'll have to wait and see. I'm just telling you, don't lose any sleep at night thinking that this evidence is necessarily going to be presented to the jury. Now, there was some other business conducted at the pretrial hearing. Like I said, we talked about the alternate suspect perpetrators. And like I said, the judge was quite adamant that they need to provide support and reasoning as to why this information was even admissible. Now, the trial is scheduled to begin August 11th, and Hippler said he'll spend the pretrial hearing laying out what he expects of the upcoming trial. The judge says, I don't like surprises. Now, seating the jury in a high-profile case will be complicated, and questions for potential jurors are a big part of the pretrial hearing. Now, Hippler said The universe of jurors will be determined. Then they'll be given a scrambled number, starting with number 1, and those jurors will come in and fill out a questionnaire. Once we have enough jurors, we stop, he said. Hippler said the questionnaire will be kept confidential and are essentially attorneys' eyes only. Paralegals and investigators can't have access as long as they comply with the rules set by the court. And if Kohberger wants to see the questionnaires, it has to be in the presence of his attorney, and he can't have copies to take back to the jail. As the jurors are narrowed down, they'll come in groups for questioning in court. The victims' families will be allowed in court for that, and a small number of public seats will be available in the courtroom as well. However, the judge said that the process will not be live streamed because he doesn't want internet sleuths and others to try and figure out who the potential jurors are. They will only be identified by their scrambled number to protect their identity. Potential jurors will be questioned privately about sensitive information and about what they may know about the case. Judge Hippler plans to seat 20 people with the jury, 12 primary jurors, and 8 alternates. And both sides agree that some of the discussion about potential juror questionnaires would be done out of the public view, and the live stream of the pretrial hearing would be shut off. They're also going to discuss the evidence that will be used at trial and the witnesses who will testify for each side. The evidence includes a model for the King Road residence where the murders took place, and prosecutors had a small replica of the house built to show to the jury. The defense initially objected to that being allowed, but the judge agreed to allow that in the case. As it relates to public viewing, the judge determined that the trial proceedings would be streamed live via the court's current streaming method. Both the prosecution and the defense brought up safeguards concerning the identities of certain witnesses, and Judge Hippler said that public interest may outweigh some witnesses' desires to remain hidden. Judge Hippler did not rule on that, but said you'll have to really convince me, which is great, Judge, absolutely great. In addition, Judge Hippler determined other victims, i.e. the 2 surviving roommates, would be able to request their identities to be protected from public viewing. I'm not sure why, since we already know their names. Anyway, Judge Hippler began by saying he would not tolerate arguments during opening statements, and any objections would more than likely be sustained. And the judge also told the prosecution and the defense to estimate how much time they need for opening statements. The judge told both sides he would be able to enter the well with permission, but must keep out of the personal space of the jurors. The judge said that if Kohberger is found guilty, the penalty phase of the trial would begin as soon as it can, ideally the next day. The jury would also stay sequestered. Judge Hippler also said the penalty for Kohberger's 1 burglary charge would take place separately, and first due to it being a lesser charge is in regards to the 4 murder charges. So there you go. That is the update on the Bryan Kohberger hearing today. And like I said, I'd be very surprised if, in fact, we get any alternate suspect testimony at trial.
Somebody is going to get in big trouble. Ooh, I wouldn't want to be the person that leaked all that stuff to Dateline. Ooh, gonna get ugly. So the judge overseeing the Bryan Kohberger upcoming quadruple murder trial says he wants to identify anyone who may have violated the gag order by leaking information from the investigation to news organizations or anyone else not directly involved in the case. Now, the Judge Stephen Hippler, ordered prosecutors and defense attorneys on Wednesday to give him a list of everyone, including staff, law enforcement officers, as well as any defense consultants who might have had access to the previously unreported information about Bryan Kohberger's internet search history and other details that were featured in the NBC Dateline episode. Yes, violation of a protection order. You know what that could get you? Contempt. You know what that could mean? Going to jail. And then you got to do some explaining as to why you did it. Anyway, the judge said he would even be open to appointing a special prosecutor to track down the leak, which likely violated this gag order that has been in place since 2023, ladies and gentlemen. Now, obviously, Kohberger is the now former graduate student in criminal justice studies there in Washington State, who is charged with the stabbing death of 4 of the University of Idaho students, Ethan Chapin, Zana Kernodle, Madison Mogan, and Kaylee Gonzalez. Obviously, the 4 were all found dead back in their home in Moscow, Idaho, in November 13th of 2022. Obviously, Kohberger has entered a plea of not guilty, and he's entitled to that presumption of innocence. But The prosecutors have said that they intend to seek the death penalty, obviously, if Kohberger is convicted. But anyway, Hitler wrote in court records, 3 orders today, in fact, that someone associated with law enforcement or the prosecution team likely violated the court's gag order. And that leak will make it potentially much more difficult and take longer to already get a jury in an already expensive and lengthy case. You know what could happen if that drags on? Yeah, not only contempt, but maybe have to pay the additional expenses. Gonna hurt. The judge also noted, importantly, such violations potentially frustrate the ability to assure both sides receive a fair trial. And accordingly, the court finds it imperative to attempt to see that the source of such leak is identified and held to account. So, like I said, Hitler has ordered everyone who has worked directly or indirectly on the case to keep all records of any communications that they've had with journalists or others outside of law enforcement about Bryan Kohberger and the investigations related to the killing. Now, it appears that Hitler had discussed the matter with the prosecutors and defense attorneys during the closed portion of Wednesday's pretrial hearing, but he also referenced the Dateline episode and the possible gag order violation during the open portions of the hearing as well. At one point, remarking that after the day the episode aired, he decided to impanel additional alternate jurors for this trial. Now, digital data and documents obtained by Dateline apparently tracked Kohberger's movements before and after the 4 students were killed, as well as his browsing history, which was not previously known. So obviously somebody leaked it. I'm going to say more than likely, unless it's a double fake, it was somebody from the prosecution's team, possibly law enforcement. Anyway, Hitler told the attorneys he expected them to file a formal request to have the matter investigated. Now, also last week, Hitler ruled that Kohberger's immediate family members will be allowed to attend the upcoming trial, even if they are not allowed to testify. Now, also, the big story yesterday was the alternate suspect, all right? And I was doing a lot of thinking about this as it relates to the alternate suspect since that order came out. And so I wanted to make sure that everybody understands the legal standard. And it's not an easy one for the defense to overcome. So let's just be clear about that. So in Idaho, the legal standard for admitting alternate suspect evidence, often referred to as other suspect or third-party perpetrator evidence, is governed by case law as well as the rules of evidence, particularly rules 401, 402, and 403, as well as relevant state precedent. Now, the defense must meet specific criteria to introduce evidence suggesting that another individual committed the crime, ensuring that such evidence is actually relevant, admissible, and not unduly prejudiced or just speculative. Now, the evidence must be relevant, meaning that it has a tendency to make a material fact, i.e. the identity of the perpetrator, more or less probable than it would be without the evidence. That's under 401. Now, Idaho courts require a direct connection between the alternate suspect and the crime. The evidence must do more than create a mere suspicion or speculation. It must point to the alternate suspect's actual involvement with some specificity. Now, the leading seminal case there in Idaho, based upon my research, is State v. Larson, and it established that evidence of another person's motives or opportunity to commit the crime is admissible if it directly connects the person to the crime charged. However, evidence that merely suggests someone could have committed the crime is completely insufficient. And then we have admissibility based upon the probable cause threshold. All right. So Idaho law places a significant burden on the defense when seeking to introduce the alternate suspect at trial. The defense must present the alternate suspect evidence to the judge in a special session prior to the trial and demonstrate probable cause. That's the same standard as for somebody to get charged. So basically what they're saying is, you've got the wrong person. You need to charge this particular person, judge. Now, what is probable cause? Well, it's when would a reasonable person believe that a crime was committed and that that person may have had something to do with it. So pretty low standard, but still pretty significant. Now, like I said, the threshold requires more than just conjecture and vague speculation. And then if it meets the relevant standard and you get past the probable cause, then you still got to do a balancing test under Rules of Evidence 403, which allows the court to exclude evidence if it has some probative value, but it's substantially outweighed by the danger of unfair prejudice, confusion of the issues, or can possibly even mislead the jury. So courts are very cautious about admitting alternate suspect evidence that could lead to basically a mini trial within a trial to try this other person. It's going to be rather interesting if the court allows that to take place. Now, I'm kind of thinking it's not going to happen, but we'll wait and see. Now, the other thing you have to consider is some United States Supreme Court case law. And it emphasized that a defendant obviously has a constitutional right to present a complete defense. And the Idaho Supreme Court has also reiterated that evidence of another suspect's involvement must be supported by facts that establish this direct link to the crime, not just somebody that may have a motive or may have had an opportunity to do so. You must show they actually did it. That's why I think it's going to be very, very difficult. And finally, the defense must provide concrete evidence, such as physical evidence, perhaps that's the glove at the scene, perhaps some blood, witness testimony, or other factual connections linking the alternate suspect to the crime. For example, in the Kohberger case, right, the defense has indicated it is pursuing a lead on an alternate suspect based upon discovery materials, which they are working to substantiate. Once again, if it is vague, remote, or speculative, it is going to be excluded. How does this fit in then to the defense case for Bryan Kohberger? Well, his attorneys have filed motions to admit an alternate suspect evidence, including the theory that two individuals may have committed the crime with two weapons supported by an expert witness. They have also referenced a specific tip about an alternate suspect uncovered in materials provided into discovery. And so how's that going to work? Like I said, the defense has to convince Judge Hippler that probable cause exists that an alternate suspect could have committed the murders. This could be the male DNA, unidentified male DNA at the crime scene, witness statements, or other direct connections to the crime. Now, Judge Hippler had set a deadline of this past Wednesday for the defense to present this alternate suspect evidence, indicating that waiting until trial would simply be too late and what could cause potential delay. And like I said, you have to have that pretrial hearing. So the prosecution may argue that the defense's evidence is completely speculative and lacks direct connection to the crime, especially if the tip or expert testimony does not sufficiently link the suspect to the quadruple homicide. Obviously, the presence of Kohberger's DNA on the knife sheath at the crime scene strengthens the prosecution's case and may make it harder for the defense to establish probable cause. So, got that probable cause threshold. It's going to be challenging for the defense. It's not ridiculously high standard, but one that you really have to meet. Anyway, if the defense fails to meet that standard, the judge will more than likely exclude the evidence limiting the defense's ability to argue that someone else committed the crime. However, the defense can submit some compelling evidence, and hey, if it's compelling, we want to know. Nobody wants to convict an innocent person. I don't even think prosecutors want to do that. So if that's the case, then let's find out. The question is, will it actually get to that level? So therefore, under Idaho law, that Idaho alternate suspect law, to be admitted at trial, the defense must demonstrate probable cause at this pretrial hearing, showing a direct connection between the alternate suspect and the crime through relevant, non-speculative evidence. And even if that's the case, the court could still keep it out under a 403 analysis, basically saying that it's prejudicial, it's confusing, and we aren't going to allow it. All right. Big news, but I wouldn't want to be the person that leaked this to the news media. And you would think, well, let's just go ask the news media, who'd you get it from? Well, there's the privilege of the press, right? They're not going to reveal their sources, but you could ask them. You could ask them and see where they got it from. But the person that disclosed it, ooh, they're going to be in big trouble.